Welcome back to the Law&Crime Network. Again, I'm Kenney Baden. We have 3 trials on deck, so you have to stay tuned because we will be live in the McStay family murder case, the Charles Merritt, who is on trial for his life in that case. The prosecution is in the middle of their closing arguments. We'll also be discussing the Stephen Jones case in South Carolina, where he's accused of killing his 5 kids. Well, obviously that wasn't a package. That was a real-life thing of the closings that started this morning in the Merritt case. That's Prosecutor Imes, who didn't do much of the questioning in the courtroom. Gene Rossi, my surprise guest, ladies and gentlemen, we have Gene Rossi. I call him the Perry Paddock, former prosecutor who's everywhere, but more importantly, he's here with us today on the Law&Crime Network only. So Gene, in California, there is a jury charge that says if facts can be shown to be pointing towards guilt or innocence, the jury must take the interpretation that proves innocence. Not that they can, not that they may be, but they must. What do you think about that?
That's a great instruction. I would love to have that instruction every time I were a defense attorney.
And how does that help the defense with this prosecutor's opening argument here?
With what this guy's closing argument mean?
Yeah, this guy, he's kind of like the closing argument. He's the prosecutor, but he's like this guy. Yeah, okay, I'll take it.
No. Well, he sort of addressed the instruction. If you have facts from which you have, you conclude it could point towards guilt and it could point towards innocence, he just admitted that you have to go with innocence.
Okay, so there was demonstrations in the courtroom this morning, okay? The prosecution took the sledgehammer out of the evidence bag, and there you go, banged it on the lectern. It's not a podium, ladies and gentlemen, it is a lectern, okay? Boom. Now, I played those, and I'm going to do it right here. I played that in the courtroom. Is that effective or not? I'm banging, Gene.
You know what? I don't know this guy. I haven't watched everything he did. I don't like gimmicks, and it comes across as a gimmick. That's number one. And the thing you got to do as a defense attorney or a prosecutor, you have to be sincere. And when you do something that doesn't seem authentic and sincere, you lose credibility. And I know this because I have done things in a trial that in hindsight, I wish I could have taken back. They were gimmicks.
Pray tell, like what?
Oh, I raised my voice unnecessarily. I pounded the table unnecessarily. I did things as a young prosecutor, even when I was a little seasoned, that I kind of regret. I did sort of, there's too many to count. But Here's one thing you don't do. You don't over PowerPoint the jury. And I just noticed when he was talking, he had on the screen his PowerPoint. And what was I doing? He's doing it right now. You're looking at the PowerPoint. You are not looking at him.
And you think it's more important? Do you think he gains credibility if the jury looks at him? You said that the jury must have credibility. How does that work then? Because I like PowerPoints behind me. I disagree with you a little bit.
No, I'm not against PowerPoint 100%. I'm against overdoing PowerPoint, where everything that comes out of your mouth has a PowerPoint slide. It's okay to use limited PowerPoint, but when you overdo it, it really makes your closing argument or your presentation ineffective. I've seen it so many times. Go back to the trial we had, the one who was representing herself. That prosecutor, who was very seasoned, he was phenomenal. Didn't use PowerPoint. He used himself.
And Gene, is the facts here. What are the facts? We're going to listen to the whole prosecution's closing argument. But it seems to me that it's important to dive into those facts that prove beyond a reasonable doubt that Charles Merritt killed these 4 people, given the fact that there's a lot of problems with the processing of the alleged death scene.
Absolutely. And the prosecutor is smart if he's avoiding the bad facts that they were arguing showed that the murders occurred in the home, because those facts are horrible. And I hope we address the venue issue eventually, but there's no way those 4 victims, the family, died in the home. There's no way. Absolutely no way.
Well, obviously the defense would love to hear you saying that as a commentator, because that's what they've been arguing. And if they didn't occur in the home, the likelihood of Charles Merritt taking, the 4 people out was slim to none. But I tend to think that the likelihood, if they didn't occur in the home, that he could be more guilty, that he killed the father after he had lunch with him in that little shed that he had, in the tool shed or wherever that was called, near the restaurant, and that the other 3 people could have been lured out of the house and killed someplace else. I mean, to me, that's obvious.
Well, here's the problem. They are charging a murder in their county. The murder, the death, the bodies were found in the Mojave Desert, which is in another county. Excuse me. If that's the case, the indictment is defective. The government has to prove beyond a preponderance that the murder occurred in their county. That's where I went to law school.
Yeah, but they're saying now, under current case law, that indeed the jury does not have to find that it occurred in this county, as long as the bodies are in the other county, that's okay. So you and I were taught one way, but I think the way of the courts now may be another way. I mean, that's what I'm seeing.
Well, that could be California law. I can just tell you federally, this dog would not hunt. They could not charge those 4 murders in a U.S. federal court. They couldn't.
Well, I think the prosecution also went there this morning, did they? I'm going to ask my producer, did they go there this morning? Yes, they probably did. Do we have... Yeah, the prosecution said they don't have to prove where these murders took place. So Gene, I mean, you're saying one thing to me, which I love, but I have the feeling that the prosecution may be right here. They don't have to prove exactly where the murders took place, as long as the jurisdiction of where the bodies were found is in the place where they're now prosecuting the case.
No, the Mojave Desert is not in the county where this trial...
That's a technicality. It is in the county where they're prosecuting, by the way. It is in the county where they're prosecuting. Where the deaths occurred is in a different county, allegedly, but the prosecution said, okay?
Right.
So,
yeah.
But doesn't that look like a technicality to a jury? I mean, if I'm a defense attorney, I'm not going to go there. I'm going to say, no, that they weren't killed in the house. And now what you're telling me, if I say that as a defense attorney, that helps the prosecution.
Well, if the judge is going to instruct the jury that it doesn't matter where they were killed, then obviously they're not going to get into, was it in the home or the Mojave Desert? I guess I'm not smart enough to understand the jury instructions in California law.
Let me tell you, there's 2 sets of different instructions that come from 2 different codes. It's very complicated in California, which is why you always need local counsel if you go in there as a foreign attorney or somebody who has to, as we said in My Cousin Vinny, blend. Okay, so Gene, getting away from the optics, here we have Prosecutor Imes. He didn't do much of the questioning this morning at all, okay, or during the trial, from what we saw when we were in the case, okay? Now, does bringing somebody to do the closing who didn't make that trial connection, do you think that in this case that was good, or is it good because he didn't do some of the questioning, which may have teed the jury off in some way?
I think it's very bad. I hate to bring up the OJ case, but in the closing argument for the California, Marcia Clark did I think the initial closing or part of it, if I recall. There was 2 or 3 months where she didn't do a witness. I think it's very bad when you have somebody who has been sitting there doing relatively little, and then he or she does the closing, because you want to build credibility. You want to build trust. You want to build integrity. And if you haven't done any direct or crosses, relatively few, if any, and then you're doing the closing, the jury's going, hey, why are you here?
Yeah, so Gene, we got a lot to watch, but you know what we're going to do now? We have to pay the bill. So we're going to take this teeny weeny little break, because I know we have a lot to talk about and a lot to listen to, and the prosecution should be back into the courtroom pretty soon. So we're going to go to a break and come back, and stay with me, all of you, please. Well, that is the prosecutor who started this morning in closing, will be continuing later on, and we expect that these closings, both from the prosecution and the defense, will go on through tomorrow, because remember, in California, the prosecution goes first, defense goes second, and the prosecution gets to come back after the defense goes with a rebuttal closing, which will happen here. So, Gene Rossi, I mean, I kind of liked where he went here now. He's talking about the fact that there were deleted checks in the computer, that there was time periods that Joseph Merritt was simply absent on the time periods, and that gives the opportunity and also the bringing up of the motive at this point, which you may not like it, but sometimes motives of murderers are not exactly cogent. So what do you think about that when he started going there in this clip?
I'm going to do even better.
Okay.
I thought the way he did the PowerPoint was appropriate. He had a little timeline. He gave him bullets. The way he did it there, I thought was good. And he also, what I liked is, he's not going to win this case by whether those little dots on the table are blood, this, that, and the other thing, whether that car was the truck of the defendant in the security video of the neighbor. He's going to get to something you can't argue, a deletion of a check, use of computers, raw, uncontested data that goes towards motives. That's how they're going to get guilty if they get guilty.
Yeah, I thought the strongest fact the prosecution has had in the case against Merritt, if there is a strong fact, is the fact that Merritt admits to being the last one who allegedly saw Joseph alive and the last one who spoke to him. I think those are the strongest facts that you can inferentially say he was involved. However, this is a death penalty case, Gene. So when you have a death penalty case, doesn't the jury want a little bit more for the guilty on the guilt phase than they would on a normal case where they may say, we may let it slide just a little bit?
Well, what you may have here is on the guilt, on the penalty, I'm sorry, let me start over. On guilt or innocence, that phase, I think he could possibly be found guilty. But when they get to the penalty phase, the jury may say, you know what? I don't feel great about the level of evidence. I know we found him guilty, but let's just send him away for life because I'm kind of unsure about the level of evidence.
Well, let's see what the prosecution did next in terms of Joseph's QuickBooks and whether Chase Merritt has any involvement in them. So while this may seem to be kind of, well, I'm really kind of bored testimony, it is not, Gene Rossi, because this goes to motive and whether or not Chase Merritt, Charles Merritt, who is not a computer expert like the person they were trying to insinuate did this crime, Dad Kavanaugh, could have gotten into Joseph's accounts when no one really knew he was dead yet. Remember, only the killer would have probably known he was dead at this point or in a position that he couldn't monitor his own QuickBooks, but got into the accounts and the checks are being written or seem to be written for Merritt's benefit, not anyone else. Doesn't this help the prosecution?
It is very inculpatory because, and I got to compliment the prosecutor, he's focusing on February 1. And he's going through the timeline. That's all good.
Right.
If I'm a defense attorney, from the beginning of this case, which now seems like 5 years ago and not 5 months, I've always asked this. Mr. Merritt is going to take the life of 4 people brutally over relatively $50,000, $100,000? That just doesn't make any sense to me.
Well, you know, Gene, but you know, when you come to murder motive and motive for murder and you get the M's, the 3 M's, motive, murder, and money, the most important bit. I mean, we see cases where people get killed in New York City for a pair of sneakers. So I'm not sure the amount matters. The question is could this guy who's sitting there really done these brutal crimes? I mean, to me, this looks more like a hit no matter what you say. Yeah. Even if he was in the computer February 1st, February 4th, February 5th, even if he was in the computer. But if it was a hit, does that exculpate him from being the person who killed, who ordered these people killed? Or because the prosecution didn't go there, the jury can't?
Oh, absolutely. I firmly believe that it took more than one person to take the life of the McStay family. There's no way that either Mr. Kavanaugh, who's out there, or Mr. McStay did this by themselves. There is no way. It just can't be done. Well,
the bodies even indicate that to me. You have Mr. McStay, who's wrapped up in that blanket-like material. He's got a rope around him. I mean, how he is found is so different from where the poor children and the mother, how they're found and how her clothes are. It just seems to me as if I were just sitting on the jury, that they were killed at 2 separate times, at 2 separate places, by 2 separate people.
I agree. Or more than 2 people.
Or more than 2.
You know what's going to decide this case, Linda? I can predict it right now. The rebuttal. Because I think the defense has a great closing lined up, and they're going to do a phenomenal job. I can just feel it. And if the rebuttal of the government is relatively weak, then he could be acquitted or it will be a hung jury.
Well, Gene, we have to go to a break, but I love you say government, because I, as a defense attorney, point to the government all the time, because the government is the big boogie person that we can't ignore.